Yes, but are they here? Maybe we'll start calling it up.
Check on independent counsel.
Okay. Where are the others? Maybe you call it up.
We are not seeing, are you seeing anybody? Because we are not seeing you. Sure, why is it the first person? So that cancer is online. It's online.
Hello?
Both of them are online.
Hello? Hello?
Okay. Okay, I've seen two learner council. Then Lagos NIC. Who is it?
Okay, if I'm not sure.
The second one.
Okay, I think
That's independent counsel.
Okay. Okay, this is Mr. Ikanyawo.
And
Okay.
Mr. Ibrahim.
Samuel Ibrahim. Okay.
Good day, my lord.
Yes, good afternoon. So you're here. Let us start.
I can barely hear the court, sir.
Okay. I'm saying that since we have seen you, we are going to begin the session.
Resume. Sorry. NICN/LA/331/2021 between Heavy Machinery Dealership Limited and 1. Kasami Yakub. 2. Matrix Global Trading and Sourcing Limited. My lord, parties are absent.
Appearances, please. Appearances.
May I please, my lord, my name is S. Ibrahim for the claimant
Okay.
applicant, sir.
Very well. Let's go. Claimant applicant. Yes. Oh, Mr. Kanyao, please unmute yourself. We are not hearing you.
My lord, I'm unmuted. Okay. Can you
Okay,
hear me
no,
now?
we are hearing you now.
Okay, my lord. Thank you, my lord.
Yes, very well.
Ebuka Eke for the defendants, my lord.
For the defendants. Yes.
My lord, I believe the matter is slated for adoption of final written address and we are ready to proceed.
Yes.
My lord, we have an application that is pending before the court, sir.
I see. Which one? And when was
It's
this filed?
dated 19th of May, 2026, sir.
19th of May.
In fact, we have two applications, my lord.
I guess it is the motion dated 19th of May 2026, but filed on the 20th.
Yes, my lord. There's a prior one before that, sir.
What date?
That one is dated 20th of January 2026.
And filed
20th of May 2026.
Okay.
My lord, I'm not sure what that application is for because we have not been served, and I'm not sure what that other application is for. I'm only aware of the application for extension of time so that he can regularize his address and then we can proceed to adopt, my lord.
Okay. This other one that was...
My lord, the defendants have all been served these applications.
I see. Have you been served the application?
My lord, I'm not even sure what the application is for, my lord. I'm not sure. I'm not in receipt of it. And if we're in receipt, I'm not sure what the application is for. Because I believe my lord at the last adjourned date had understood that this matter was going to be adjourned for adoption of final written address. And counsel on his part committed to filing his address at the last adjourned date to enable us file our reply. We have in advance filed our reply, even despite the fact that council's address has not been regularized, so that we can proceed, for adoption today. So, my lord, I'm not even sure what the other application is for. I'm not sure what the purpose of that application is for. I'm not in receipt of it, my lord. And if there's records that have been served, my lord, I don't know what the application is for.
Okay, the application is for an order of the court extending the time within which the claimant applicant may file its written address in this matter.
So that's the later one, sir. The later one, sir. This the first one is an order granting leave to the claimant applicant, sir.
Okay.
The one dated 20th January. That's the one we prefer to move first.
20th January. Okay. This one is... Is it the one you are asking the court to grant leave to the claimant applicant to reopen its case?
Yes, my lord. To call additional witness, my lord.
To witness Mr. Matthew Curry.
Yes, my lord.
And to file a list of additional witnesses.
Yes,
in
my
the
lord.
manner showed in the attached list of additional witnesses marked as
yes, my lord.
1. Have you been served?
I have not
They have
been
been
served.
served, my lord.
My lord, I have not been served. And in any event, I'd like to make the submission that both applications cannot stand. You have an application to adopt a final written address, which brings the end of the case, to a close, rather. And then you have an application that wants to reopen the case. My lord, I'm not sure how both applications can stand before your lordship in this particular event, my lord. And counsel has made tireless submissions that, some documents were omitted, which the court have discountenanced, as at various previous adjourned sessions, my lord. So I'm not sure how we are to proceed today, my lord, if council insists that he wants that application to be heard. I would make the submission that I have not been served. If at all that council wants to proceed with that application, I have not been served, my lord. And council ought to have
Your
brought
Gino
this
was served
application-
in court at the last
My-
adjourned date.
my
If he
lord,
didn't share with you, it's
council
a
ought
different
to
thing.
have
He has been
brought
served
this
in court at the last adjourned date.
council ought to have brought this application or moved this application even as at several previous adjourned dates, my lord. Till today, my lord ordered the 200,000 naira cost against council on the last adjourned date. I have not been paid that cost, my lord, for council's, inability to proceed with his matter that he filed in court personally. He filed this court personally on behalf of his client so that we can proceed and allow the court to determine the issues, on the merits, my lord. Till today, I've not been paid with that cost. If counsel wanted to reopen his case, he ought to have done so a long time ago, not at the stage of adoption. My lord, this is an abuse. My lord, this is unwarranted. And this has now stalled everything, my lord. It just means that we are going back to reopen the case and open wounds that have been closed. My lord, this is matter slated for adoption. He has filed his application to regularize his written address. So I don't know how both is supposed to proceed. I'm not sure, my lord. I'm a bit at a loss. I'll leave it at the court's discretion to know how to proceed, my lord. But I've not been served.
Okay. Mr. Ibrahim. Mr. Ibrahim.
Yes, my lord.
You said the court the motion you want us to look at. It is for another granting leave to the claimant applicant to reopen his case. And remember that what you are here for, the business of the court today, is for adoption of the final written addresses. So how can we come and reopen the case?
My lord, this application was filed before the last adjourned date, and we sought to move it there, but because you were not served, we adjourned it to today, sir. But because your lordship now ordered that we should also proceed to file final written address, I obeyed the honorable court to file the written address. But we have this application that is very, very key to the claimant's case. It's very key, and it's for obvious reasons. It's for obvious reasons.
You know how you are going to conduct your case. I wouldn't know. But what I'm saying is this: at a stage when we should be hearing the final written addresses of both Learned Council to the parties, we are now hearing an application for another, granting leave to the claimant applicants, not even the defendant. Claimant, that is their case came before the defendant. To reopen his case, call additional witnesses. That is systematic.
Yes, my lord, because the reasons are obvious, because, my lord, we stated the reason why we want to call that particular witness to come and tender that document. Because the document, we admitted that document, we tendered that document, the document is the cost record. But I don't know what happened, it was not allocated any exhibition. The record, the type record excluded it. It excluded it. The handwritten record has it.
I don't understand.
That's why we filed that address. But this application, we want to move one way or the other. If your lordship refuses it, fine. But let it be on record that it was filed, sir.
Was it filed and was it heard in the open court?
Yes, my lord.
And then you said it was not marked as an exhibit.
It was not, my lord. If your lordship can look at your own handwritten record, your lord, you should see that you made a reference to that very document. I don't know what happened. I don't know what happened.
My lord,
and it's in the court file.
My lord, if I may remind the court, my lord, if my lord...
I'm talking, let me finish first. Let's not be talking. Let me finish. When I finish, you talk.
Sorry, sir. You can finish, sir.
Thank you. It's there. When I check it, it's there. It's there in the court record. The document is there. And they know it's there.
Okay, can I speak now, counsel?
In the Institute of Justice, we need this document to come in. Your lordship can look at your record. You can look at your record, not the one that they typed. Your Lordship can look at their own record. It's mentioned there. I can't come here and be lying on my own. On my call, I can't come here and be claiming what is not there. And council made reference, very insulting reference the last time that maybe we smuggle it. That is so uncharitable. I just kept quiet because I allow it to fly because on my honor, I can't do that. I fear God. The document is there. I don't know what happened. Because I remember the last time I came that your Lordship wanted to admit it, I think they raised objection. And then I think there was an adjournment. This next date, I wasn't in court. I think somebody came. Maybe that day, the person didn't avert the mind of the court. I don't know what happened, but the document was tendered. They raised an objection, I think. It wasn't tendered. Maybe our Lordship said maybe that the next adjournment they will address it. I wasn't in court.
If I may speak, my Lord, at this time, my Lord had painstakingly over 2 adjournments, if not 3 adjournments, went through its records with its registrar, his chief registrar, over the claims of the claimant regarding this document that had been supposedly tendered. My Lord found no record whatsoever. So is counsel submitting before your Lordship that the court's record is wrong? That the court did not take notice of its records? My Lord,
The typed record is wrong. My Lord, handwritten record
is an
is right.
indictment on the court. Counsel, you said,
The typed record is wrong.
Counsel, you said, Counsel, please let me finish
The
my submission.
handwritten
You have
record
made
is
your
right.
submissions. You have made your submission. Let me make my submission. My Lord went through her records painstakingly 3 times. With the registrar of this court. My Lord, we suffered a lot of adjournment because of this issue. And my Lord, it was already resolved, which is why the in courts have now brought this application. Why counsel is relitigating this issue is it amuses me, my Lord. Now, counsel has brought an application to extend his time to file his adoption of written address. And he's bringing an application to bring in a new witness, my Lord. How do we proceed? Those applications are contrary to each other. They cannot stand.
Let me move my application, you oppose, then the court give a ruling. That's all.
Have you ever thought of how tidy the court's record will be if we have gone to the end of the case and then all of a sudden the court will open up the case and take an application that should come before the final written address?
In the history of justice, my Lord, even before the judgment, my Lord, if the Lordship deems fit, it can even amend, my Lord, with respect, sir. Even on the day of judgment, my Lord.
There are a lot of authorities that says that
in the history of justice.
My Lord, there are a lot of authorities that says that the court cannot arrest the judgment of courts. Counsel cannot arrest the judgment of courts, even if counsel wants to make that kind of submission. My Lord, all I'm saying is that I have not even been served with this application. This application to recall witness have not been served, and I am supposed to be given that opportunity to respond to that application. I have not been served, my Lord. I haven't even been served. I've not had the opportunity to look at it or respond in any event.
Your counsel who was in court was served.
My Lord, I have no record of this application, my Lord.
He was served.
I have no record of this application. I see no reason why I would not even want to respond to it. And my Lord, I thought counsel had abandoned this application. My Lord, if my Lord can go through its records, counsel had indeed abandoned this application.
So you knew about the application then?
You
knew about the application. You knew about the application.
My Lord, my submission is that by filing this application to extend his time to file a written address, which is later in time, counsel indeed has abandoned its previous application. That is my submission, my Lord. You cannot file an application earlier in time which says you want to recall witness and then go ahead and file an application to extend your final written address. By filing the application to extend his final written address, he's basically saying, I wish to abandon my earlier application and proceed.
Counsel, please, when two of you finish your conversation, you let me know. Because all of a sudden I'm supposed to have known that that somebody should be examined, and then while the case, the business of the court today is for adoption. And this date we have been taking dates for adoption of final written addresses since December 2025. And I don't know when this application came up. This
My Lord, I was not even aware of this date. I travel. I'm out of Lagos, but when his colleague in the office called me, and since it's Zoom, that's why I had to do it, because I went outside Lagos. I'm in Abuja for a different matter, and I had some copies made to me. I was just asked them to write the code. I wasn't ready, but just to show that I am available at any time, and I want us to make progress.
But what
this application
was
left for me.
Upon coming back, you take up your case file and read and know what we have done and what we have not done. Now, how do we suddenly resolve this matter?
My Lord, it's an application before your Lordship. If your business or record permit, we'll move it. They respond. My Lord, give a considered ruling. They will proceed from there.
My Lord, sir.
So we, the matter was adjourned for adoption. So all of a sudden, I will hear another application and I move and give evidence and give a ruling. So that is the. Can you remember when you filed this application, Mr. Ibrahim?
It was filed on the same day. The two applications were filed same day, sir.
Of when?
May 2026, sir.
May 2026.
Yes, sir. Because the client, the witness, insisted that he must testify. He is the MD of the claimant. He has been following.
Let's check.
So it is surprising that a claimant who filed this matter, who stated this matter against the defendants, is dragging this matter for such a long time. My Lord, may I also intimate the court that as at the last adjourned date, the court awarded cost against the claimant in the sum of 200,000 naira. My Lord, to date, we have not been paid with respect to that cost. Now, counsel has brought an application now, notifying the court that he wants to reopen his case, and has subsequently filed an application to extend his time to finalize his final written address. My Lord, again, my Lord, I call on the court's discretion to determine, both applications. But my Lord, in any event, we have not even been served with that application to recall his witness or to call additional witness. We have not been served with that application. There is no proof of service before the court, and we have not been served with such application, my Lord.
So,
if your application is that, my Lord, if his application is that there is no proof of service, we serve his junior. If they say there is no proof of service, my Lord, we take an adjournment to do the needful. But that application was served in court. Was filed and served in court.
I'm telling you.
And on the issue of course, my Lord, if we are aware that this case was coming up today, we'll have paid them because we didn't know the case was coming today. And the client normally they send the money on the day the case is coming up. We were not aware the matter was coming up today. He knows the last time we paid, it was on the day the matter came up. That's how the client behaves. He's not based in Nigeria. If we are aware, we'll have paid him even before today or today. It's an impromptu thing. You can look at my background. You know that I'm not in Lagos. I'm not in
the court order is impromptu. I don't understand.
That the issue, of course, is not an issue. I can get them to pay him today. It's not an issue. So if you want service, we can take a day to effect another service on him again if he's denying the initial service and file proof of service. But in the interest of justice, we need this application to be heard today. My Lord can grant or refuse, so that we'll move on.
Okay. So what are you saying about the cost?
No, of course, my Lord, I'll get them to pay today. Before close of business today, they'll pay.
But if you disobey the court, you are not supposed to.
Like I said, they are not aware that the matter is coming up today. That's why they couldn't join.
The court is not supposed to, hear whatever you're saying until you
Comply with the directives of the
You
court.
obey the court's orders.
My lord, this we were not notified of this case in time. In fact, thank my learned colleague on the other side, his junior, who called me. He called me, and the court register sent me this today. Today, she sent me this in today. But that gentleman called me yesterday night that am I aware that he saw it on the platform. I said, no, I'm out of Lagos.
Apologies, counsel. My lord, as claimants, my lord, we did our duty, but we were not notified as well. But the court posted it on its WhatsApp platform, which everybody has access to. That this matter could not be heard.
Not everybody has access to. I've complained severally that I don't have access.
You want to do your due diligence.
Listen now. I rely on the post that it was sent to. That there's this notice that is sent. There's a notice that is always sent.
Huh?
There's a notice that is usually sent to counsel. And I was looking forward to that.
Of advocacy is not admissible.
My lord will bear me witness that I am trying to be as candid and candor, as possible. I'm not trying to argue this time around. I have learned from my previous mistakes with this court that my lord does not appreciate this manner of approach when it comes to submissions and advocacy, my lord. So, my lord, my submission, my lord, is that counsel ought to have done the needful. If he is claiming that he was not aware, he is aware. He is present in court. The facts and evidence speak for itself. He is openly addressing the courts. So how can counsel say he's not aware of today's dates? Secondly, my lord, we as defendants did our due diligence.
Don't talk like that because you want to talk. Ask your Gino. Your Gino will tell you. He called me to inform me. I cannot be aware and come and be saying I'm not aware. Okay, is my client? Is he online? I just informed him a few minutes ago.
Mr. Ibrahim.
Will I come and be telling the court I'm not aware?
Mr. Ibrahim.
Yes, my lord.
The bottom line is that the opposing counsel is saying that he has not been served with this. So there is no way we can just go on with it now.
I will take a day to effect that proper service and file proof of service. We'll take a date, if that's what you want.
You obey the order of the court.
Yes, we will obey today, sir.
You serve them.
Yes, sir.
You serve them. Yes, serve them again. Because he cannot have it and say he was not served. Serve them again.
We serve them. We'll pay costs today. We serve them.
Sir, I have one application, my lord, an oral application, my lord. My lord, if today's date is going to be truncated, I'm going to also ask for cost. My lord, we painstakingly drafted our reply address. My lord, if I may,
the counsel that was involved, let him come and testify to the court that he was not served.
I don't interject. Why not allow me to speak?
I'm just going to stand up. I'm going to rise and leave you here when you finish.
No, but my lord, sir, my lord, you should allow me to make submissions before this court. Please, my lord, I'm not doing anything that is against the rules of this court. I have an oral application which I want to move, my lord. And I've asked my lord, sir, that we will be asking for cost because today's proceedings has been truncated. And these are my reasons why. My lord, we have painstakingly taken our time to file our reply on points of law. My lord, this is not even just an issue of, we sat down today and we have to basically look at the evidence, counsel submissions, and every other thing to ensure that we file our address today. My lord, today was slated for adoption of final written address. And my lord, we cannot proceed any longer. So, my lord, I'm going to be asking for cost. My lord, counsel is seeking to reopen this case entirely. Even after we have gotten to this stage, after several adjournments of giving counsel the opportunity to proceed and adopt his address so that my lord can adjourn for judgment. So, my lord, I'm going to be asking
I've checked
my lord, if I can say something.
The
reply to the written address he's talking about was even served yesterday. They served yesterday. They just sent me a copy now. They served yesterday. Okay. They are talking that he served yesterday.
But all these things are after your motion on notice, which you filed on the 20th May, 2026. Yes, okay. Even though I see it here in my cost list, but the other party has not been served.
Yes, my lord.
And I cannot expect them to, I cannot expect this court to take this motion when one side has not been served.
We
Secondly,
apply for a short date, my lord. Very short date.
that short date,
Yes, my lord.
with before which you must have paid the cost of the last adjourned date.
Yes, my lord. We'll pay, my lord. We'll pay. He wants cost, we'll pay.
Okay.
We'll pay him.
Okay.
No, sir, I'm asking for cost, my lord. That is my oral application before your lordship for truncating today's proceedings. And I'll be asking for cost of 1 million naira, my lord, because this has gone for too long. And this this practice should be abhorred in any other jurisdiction or clime. My lord, this is not even out of sentiment.
Mr. Kanyam, you can't be asking for a cost of 1 million naira because he has not paid up this 200,000.
That's fine, my lord, but the idea of cost is to teach.
He's not entitled to cost because I served his junior in court.
My lord,
I
it is
served his
obvious
junior in
that
court.
counsel
He's
is
coming here
not
to
learning
deny without
from.
bringing the junior to come and say he was not served. Bring the junior to come and show it that he was not served. Let him come and say he was not served. I'll be okay.
My lord, sir, you were addressing me. You said I cannot ask for cost of 1 million naira. I just want to give.
I said that is a little bit much.
My lord, it's fine, sir. But my lord, the idea of cost is to make sure counsel is on his toes doing his work as a representative of the party he's representing. My lord, over and over again, counsel has proven that he is determined to forestall the successful closure of this matter. My lord has issued cost twice against counsel. It is obvious that counsel has not learned from his mistake. My lord, I'll be asking for cost. Even my lord, sir, if my lord has advised me that I cannot ask for cost of 1 million, no problem. I withdraw the issue of 1 million naira. My lord, I'll be asking for cost of 500,000 naira, my lord. And I humbly do so, my lord, because this practice is abhorred.
This is what you are going to do, please.
Yes, my lord.
This is number one. This matter will be adjourned to enable Mr. Ibrahim do the following. Pay the 200,000 costs awarded the other day. Secondly, for Mr. Ibrahim to serve you his motion on notice, which was filed on the 20th day of May 2026. Then the third one is for Mr. Ibrahim for scuttling the court's
Proceedings for today.
The proceedings of the court today, for scuttling it, he should pay a cost of 100,000 naira. Then the matter is
I'll not object, but I'll leave him with God. I'll not object because he claimed he didn't know that he has not been served. I'll leave him with that. As the court pleases, it's okay, my lord.
Yes, I leave him to that. Then the case is now adjourned to. Please give me a date.
Yes, madam. November, my lord. November 26, my lord.
No, this is what we are saying. November
26.
My lord would have been adjourning for judgment, and we are going to November to reopen a case.
You cost it. You cost it.
God, my lord, counsel is saying I cost it.
Okay.
You were served. You denied that you were not served. You cost
it.
All right
for you, Mr. Kanya. Is that all right for you? And Mr. Ibrahim.
November, my lord. Right November what?
26th, you said?
Yes, madam. Yes, madam.
26th November.
My lord,
2026.
My lord, if it's 2 p.m., November 26, 2026.
Yes.
2 p.m., my lord, is convenient on that day. If it's a Thursday.
It's convenient, my lord. It's a Thursday. It's convenient, sir.
Okay.
At 2 p.m., my lord. 2 p.m., my lord, will be convenient.
Yes. But this will be for definite hearing of the final written addresses of both learned counsel to the parties. Did you hear me? The first one, you paid the cost of last time. Secondly, you serve the motion dated 20th May 2026 on the counsel to the claimants.
Yes, my lord.
And then, secondly, you pay a cost of 100,000 naira for scuttling the business of the court today. Because if you check, every other
As the court
person
pleases,
is on.
no problem.
Yes.
My lord, sir, what about the application concerning opening the case? Because my lord has just said that the matter will be adjourned for definite hearing of address on the 26th.
That is
So-
why I said he will serve you. You look at it and then
Okay.
know whether what you are going to reply.
Okay, so are we going to have like an earlier proceedings to determine that application first because my lord would have to hear the application to reopen the case before we can go to address. That way, my lord will determine whether the court wishes to proceed ahead.
No, the motion I said he should serve you is that motion he said he wants to reopen the case.
Yes.
When he tells you, you know what to do.
Yes, my
And
lord.
then,
So
yes.
yeah.
As the court pleases.
Yes.
Yes, my lord. What I'm saying, my lord, sir, is that my lord will determine one way or the other regarding that
Yes.
application, whether
Yes.
the court should reopen the case or not. So
Yes.
I'm saying that the 26th of November may not work for definite hearing of address if my lord decides
Allow
to
the court
reopen
to
the
rule.
case.
Now, are you the one that is allow the court to rule, sir?
My lord, sir, I'm just bringing. I'm trying to assist the court.
What you're asking is whether it is the day the court will rule on his motion.
Yes.
Because you cannot take effect on that date.
Yes.
So well, it's possible that the court may rule and the business of the court may still go on, depending on how the court rules.
As the court pleases.
As the court pleases.
Hi, Mr. Corey. Okay.